Let's pretend the FTC is right. Is Coppa compliance one button away? Hello and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law Business Law Firm of Northville, Michigan. And today, if you are not yet sick of YouTube and Coppa compliance questions, then, well, I've got an episode for you. Yesterday, we did a deep dive into some of the weaknesses we spotted in the FTC's claims of authority over content creators under the Coppa Rule in particular, and how their claims have certain weaknesses when that rule is compared to the actual statutory authority given to them by Congress, including but not limited to whether or not content creators are true website operators that even have the logistical capability of complying in full with the notice and consent requirements that Coppa actually puts forth. Today, we're going to look at it from a slightly different angle. We're actually going to look at it pretending that the FTC is 100% correct. As I said in yesterday's video, one of the things that we have to keep in mind about all of this is that regardless of whether or not the statute says the FTC can do something, whether or not the rule says it can do something, the FTC still represents a tangible threat to creators because they have a virtually limitless store of lawyers and store of money to make somebody's life miserable should they choose to do so. And by the time you would win your court case, you could very well be bankrupt. Certainly your channel wouldn't be very useful. And the FTC will have won practically, even if they don't have the legal right of way. It's one of the reasons that pro bono advocacy groups out there with lawyers are prominent in this space and in constitutional law spaces, because very often it would be very much too expensive to bring suits against some of these large actors, whether that's a government agency, whether that's a giant corporation. It becomes very expensive. And unfortunately, that's the reality of the legal system in the United States. So we're going to pretend that the FTC is right, because one of the things that I've gotten a lot of in my comments, in my DMs, in my emails is, okay, Rick, should I just label everything as for kids? How can I be Coppa compliant? What is the deal here? And as I've talked about in my earlier videos in this series and in virtual legality in general, I can't give specific legal advice. I can't give that advice without a client-attorney relationship, which this series doesn't create. You get those disclaimers a lot, especially in this series, because I know content creators are listening. But this is for information. This is for education. This is one man's opinion on exactly what the FTC is looking at, how they are wrong, in some places how they are right. And I will tell you, different lawyers disagree on these things. So earlier this morning, I want to give a shout out here. I actually had a conversation with Jeremy Johnston, who has this YouTube channel called J House Law. I believe he also has another YouTube channel that he does with his whole family called J House Vlogs, I believe. But we had a great conversation for about a half hour. He has taken on this concept, this Coppa issue with YouTube and the FTC and everyone else. He has taken it on directly. He helped write, I believe, some of the complaints and some of the petitions against the FTC. He has recommended that people that are concerned about this go forward and give comments to what the FTC is currently looking at with respect to the now presently 2013 Coppa Rule, which it was presenting for comment for potential expansion. Maybe if it gets enough comments, it'll narrow. If you are interested in these videos, I recommend checking out his channel. I also recommend talking to the FTC, submitting those comments. If this is of interest to you, that can, in part, sometimes be valuable. It's often very difficult to move a federal agency from its existing position or to convince them of a groundswell of support on something. But if it is of interest to you, I highly recommend you check out his site and check out his directions for how you can get in touch with the FTC. But as part of that conversation, he disagreed with me on certain of the weaknesses of the FTC's case. He said, hey, Rick, you complain about operator definitions. You complain about a lot of stuff here. I think it's potentially a stronger case than you let on. And that's lawyers. That's lawyers talking to each other. Different lawyers can have different opinions as to the relative strengths and merits of their cases. We had a very good conversation. I still believe the FTC's position is an inherently weak one from a legal perspective. Although from a practical perspective, they could certainly make your life miserable enough to bankrupt you. So please do keep that in mind. But from a legal perspective, I think it presents more issues than he would suggest. And in his suggestions, in our conversation, he said, hey, can I send you some materials that I've collected over the months about this stuff that you can look at, that you could potentially talk to your viewers about. And I said, absolutely. And so this video is actually a function of some of the materials he sent over. He actually sent along the original complaint as amended that the Federal Trade Commission in the state of New York made against Google and YouTube before the settlement that we saw in early September of this year. And I think it's worthwhile to look at exactly how they framed how they might bring content creators into the fold, and why, even though people are asking, how can I best be COPPA compliant, and we don't want to give legal advice to specific situations, there does appear to be a fairly simple solution to making sure that your specific channel, if we pretend that the FTC can make a case that you are an operator and otherwise have all these different obligations under COPPA, if that is the case, if we pretend that is the case, how you can get compliant relatively quickly, at least based solely on the complaint that they made against YouTube earlier this year. So let's take a look at what's actually complained about here. We've got a lot of legalese. We've got a general description of the Coppa Rule, and we've got then a description of the defendants, a bunch of other definitions, and then an overview. It says, as described below, commercial entities operating child-directed channels on defendants' YouTube platform are operators under the Coppa Rule, as they permit defendants to collect personal information, such as persistent identifiers for use in behavioral advertising on behalf of those commercial entities. In numerous instances, defendants, that's YouTube, have actual knowledge they are collecting personal information from users of these child-directed channels. Through this actual knowledge, defendants are deemed to be operators of a website or online service directed to children, and at no time have defendants attempted to provide parents with the COPPA-specified notice of their information practices or obtain verifiable parental consent. So what the FTC has asserted here is that Google and YouTube have gone and they have used persistent identifiers to identify people that interact with their YouTube service, and they don't necessarily care whether or not those people are children. Now you might say, hey, Rick, one of the things that popped out here is that YouTube requires you to be 13 years plus in order to sign on with an account of YouTube. And absolutely they do. So there's some protection there. But the issue here is in the following sentence. As Google describes the information that they collect, it says, when you're not signed into a Google account, we store the information we collect with unique identifiers tied to the browser application or device that you're using. This helps us do things like maintain your language preferences across browsing sessions, or as the FTC claims, it allows them to, regardless of whether you are logged in or not, regardless of whether you're an adult, a teenager, a child, whatever, to persistently identify you. And under the actual Coppa Rule, as it stands right now, per the 2013 amendments, having a persistent identifier out there constitutes personal information, right? Personal information for purposes of this rule means a persistent identifier that can be used to recognize a user over time and across different websites or online services. Such persistent identifiers include, but are not limited to, a customer number held in a cookie, an internet protocol address, a processor or device serial number, or unique device identifier. Now, we can talk at length about whether or not this definition, as promulgated by the FTC under their rules, is in full comport with the actual Coppa Act that gives the FTC its authority here. I think it's probably too broad. But again, we're pretending that the FTC is right. So the FTC has this rule in place. It says you can't have a persistent identifier. And if you do have a persistent identifier and you collect child stuff from a child-directed website, then you could potentially be in trouble. Now, you'll also note from the complaint one thing that I read relatively quickly, which is that as described below, commercial entities, your content creators, your channel providers, are operators as they, essentially because they permit defendants to collect personal information, such as persistent identifiers for use in behavioral advertising, on behalf of those commercial entities. So we can talk about whether or not that's actually a legitimate definition here. Again, we're pretending, but I would point out that this essentially assumes the answer to the question. These folks are operators because they allow people to collect personal information is a necessary but not sufficient condition to actually being found to be operators under the Coppa Rule. Under the Coppa Rule, you have to first operate a website or service. And I would argue very strenuously that content creators who don't have any authority of how YouTube works, its HTML code, anything related to it, are not the operators of the website. And so regardless of the fact that somebody else is collecting data, potentially on their behalf, quote unquote, regardless of that fact, they can't be deemed operators. So while, yes, you need to show that they're collecting personal information, and you need to show that in this case, in order to fall under your Coppa rule, that it's being collected on their behalf, regardless of that fact, if you don't operate the website or service, I think you've got a major definitional problem, and it's one that's skipped here. And the reason it's skipped here is because these channel operators, they are not the defendants in this case. So they don't actually need to address channel quote-unquote operators. They just need to kind of say a sentence here and get YouTube under the umbrella, because who they're really after is YouTube and those $170 million. But note also, they say persistent identifiers for use in behavioral advertising. And that's going to be key here, because the FTC's main complaint is that YouTube and its channel quote-unquote operators are using persistent identifiers for behavioral advertising purposes. And that is distinct from contextual advertising purposes, and we're going to talk about that in just a second. But here's the main paragraph I wanted to point out. Here's the crux of the FTC's ability to say content creators, if they are in fact operators, which we are assuming for purpose of this video, that content creators are permitting YouTube to collect this data for their benefit. It says, beginning in January 2016, defendants offered channel owners the option to disable behavioral advertising on their monetized channels. To turn off behavioral ads, the channel owners are required to actively check a box in the advertisement section of YouTube's Advanced Video Manager Options menu. The checkbox that allows the channel owner to opt out of behavioral advertising contains text stating that doing so may significantly reduce the channel's revenue. When a channel owner opts out of behavioral advertisements on a monetized channel, defendants serve contextual advertising on the channel, which generates less revenue for the channel owner and defendants. So understand, the basic premise here is that YouTube's default rule is that this box is unchecked, that behavioral advertising is allowed. And the implied premise here is that if behavioral advertising isn't allowed, then perhaps these channels would be treated differently, that we wouldn't have this same concept of potential violations of Coppa. And that's important because we're going to read through those rules and we're going to discuss exactly why that interpretation might hold. But the point is, they are trying to bring channel creators under this ambit because there is this box that starts out unchecked that says, hey, turn off my behavioral advertising. Now, we should note here, because I think it's important, that when you actually look at what this box says, and I've pulled it up here on my personal YouTube talking about monetization of the last video, but just in general the settings here, it says advertisements, disable interest-based ads. If you select this option, personalized ads will not be shown on videos on your channel, such as ads based on a viewer's interests or remarketing ads. This may significantly reduce your channel's revenue. In addition, earned action reports and remarketing lists will stop working for your channel. Now, remember what we've talked about earlier in the series. Coppa is about data collection. There is literally no reason outside of this whole thing, and you're watching Virtual Legality and all this stuff going on in the news, to believe that checking or not checking that box means that YouTube is violating or not violating Coppa in what its responsibilities are to parents in respect of notice and consent. There was no reason to believe as a content creator that YouTube wasn't doing what it should do under the law, and every reason for content creators, which aren't necessarily going to be as legally sophisticated and certainly not data protection sophisticated as YouTube, whose job, whose innate role in this entire relationship is to collect data and serve ads and to provide the infrastructure for these videos to go up. There is no reason to believe that those content creators would have greater information on this. And so whether or not you checked or didn't check this box really shouldn't impact the FTC's interpretation of this. Furthermore, regardless of whether you check or don't check this box, YouTube isn't changing the fact that, as we talked about in their privacy policy, they're still collecting data from folks. So the question becomes, why would anybody uncheck that box? And does this actually even lend itself to thinking about behavioral advertisement versus contextual advertisement? And I would argue that point as well. But again, the video here is pretending that the FTC is right about all these things and how people might be best situated to comply. So along with this overall complaint that Mr. Johnston provided, he also provided a little bit more context. And that context was in the 2013 Coppa Rule itself. And we looked at this briefly at the end of the stipulated order against YouTube in our last video because we were talking about the dissent to how this rule actually operates. But there's a little bit more in here that I think is pertinent because it does talk about various content creators and the fact that they want to attach their liability to content creators in a third-party space. And so I've pulled up here, this is a description of all the comments they received about how problematic that might be, especially when you bring in third-party partners and the fact that the content creators that may or may not technically operate the website will have control or access to the data. And so I've pulled up here a little bit that says a little bit about how the commission thinks about this or thought about it as of January 17th, 2013. So they got all these complaints, very similar to the complaints that I raised yesterday. And one of their responses is, the commission reasoned that, although the child-directed site or service may not own, control, or have access to the personal information collected, such information is collected on its behalf due to the benefits it receives by adding more attractive content, functionality, or advertising revenue. The commission also noted that the primary content provider is in the best position to know that its site or service is directed to children and is appropriately positioned to give notice and obtain consent. Now let's think about that. So they get a lot of complaints from people that say, hey, you know, when we use, in this case, plugins, right? The phrase of the day in this set of rules or rule comments in 2013 is plugins. I don't know that we necessarily think of these as plugins. These are services provided by a website operator such as YouTube, but we don't have control over how they collect their data. If YouTube were using persistent identifiers that captured children and they otherwise had a notice and consent set of rules, a website you could go to, the things that are required of them by Coppa, then none of this other stuff would happen. And so the commission presupposes that someone has to be on the hook for that. And rather than having YouTube on the hook for that, which does this for a living, it makes the most sense to have an argument against content creators because they're in the best position to know that they're directed to children and they are appropriately positioned to give notice and obtain consent. We talked about this yesterday, but if I said to you, hey, you want to comply with Coppa, you're a good, well-meaning, law-abiding citizen, all you have to do is give notice and obtain consent from the parents of the people whose data on your behalf YouTube collected. How do you go about doing that, right? And that was the complaint. It's a legitimate complaint. The commission doesn't care about that. They say, hey, somebody's got to be on the hook for it, and we think you're probably closest. And there's other notes in here that say, hey, you know, we also think that maybe you can sign contracts for these things, and you have some leverage over the YouTubes of the world, because this is conceptually not thinking about this relationship. This is conceptually not thinking about an international, multinational company like YouTube that has essentially under it hobbyists and various people of different entrenched interests or not that are putting videos up on their service, and that YouTube obviously has contracts of adhesion and you can't control whether they comply with Coppa or not. They're thinking about this from a different perspective, like maybe you're creating a software app and you go and you want to implement a third-party plugin and you can put in the terms of that contract that, hey, you have to abide by Coppa. And that's how this is basically premised. It's not premised as to what we're discussing. The commission also believes that the potential burden on child-directed sites discussed by these commenters will be eased by the more limited definition of persistent identifiers, which we talked about, the more expansive definition of support for internal operations, we're going to come back to that, and the newly created exception to the rules notice and parental consent requirements that applies when an operator collects only a persistent identifier and only to support the operator's internal operations. So again, they're responding to these comments, all of these comments that mirror our own from this week, the other comments we are seeing from content creators in YouTube and all over social media and the internet this past couple of weeks. And they are mirroring those comments, and what the commission says is, hey, we think you've got a certain amount of out in our definition for support for internal operations. So that becomes pretty key to this whole thing. So let's go back to the rule as it currently stands today and look at what this support for internal operations definition actually allows. It says, support for the internal operations of the website or online services, for purposes of this discussion, means those activities necessary to serve contextual advertising on the website or online service. Now, someone might look at this that's not a lawyer, that isn't fully vested in the FTC's parlance or the parlance of advertising agencies. Look at that and say, hey, Rick, you solved it. If support for internal operations of the website or online service means contextual advertising, that's what we're talking about, right? Unfortunately, it's not. If we go back to the rule, one of the things that pops up is that contextual advertising is the delivery of advertisements based upon a consumer's current visit to a web page or a single search query without the collection and retention of data about the consumer's online activities over time. The counterposition to contextual advertising is deemed to be behavioral advertising. And there's a bunch of extra comments. I'm not going to bore you or waste your time with them. But behavioral advertising is what the FTC is concerned about. It's what they accused YouTube of doing. And it's what that button, deep in your various advanced settings, if you're a YouTube content creator, is supposed to do. It's supposed to say, you're okay to do behavioral advertising or you're not okay to do behavioral advertising. And it would be helpful if YouTube actually used the language that Coppa uses and doesn't call it interest-based advertising, because interest-based covers, in my opinion, both contextual and behavioral. It's not clear as to what you're doing when you hit that button or when you don't hit that button. But based on the FTC's description, and I don't see any reason to disagree with them on this point, it appears that if you don't hit that button, you are allowing behavioral advertising. And if you do hit that button, you are not allowing behavioral advertising. And YouTube is limited to contextual advertising. So with that all in mind, if we say contextual advertising is support for the internal operations of a website, what effect does it have on the operation of Coppa? Well, remember, the general rule doesn't have anything to do with labeling. It doesn't have anything to do with the content you are allowed to make. It says it's unlawful for an operator of a website directed at children, which is what we're concerned about. We're pretending that we are already in that bucket, that the FTC is right to call channel creators operators for this purpose, that somehow the FTC has a good claim against you, that you are operated as directed to children. Then what do you have to do? You have to provide notice on the website about what information you collect. You have to obtain verifiable parental consent. You have to provide a reasonable means for a parent to review. You can't condition a child's participation in a game based on them disclosing information that you wouldn't otherwise need. And you need to establish and maintain reasonable procedures to protect the information, which again, you're not physically collecting here, but we're going to pretend that this is all apt. So the biggest issues here are provide notice and get consent. That's what YouTube should have been doing all along. They have demurred on that. They don't want to do that. So instead, it falls to you. And if we are in this bucket, you say, okay, why is Rick talking about all these various definitions? And the answer to that is here in Section 7 of 312.5, parental consent, which actually applies to Section 312.4, the notice provision as well. And it says where an operator collects a persistent identifier, which is all we're talking about with the FTC's claim against YouTube, and no other personal information. And such identifier is used for the sole purpose of providing support for the internal operations of the website or online service. In such case, there also shall be no obligation to provide notice under 312.4. So that first sentence doesn't make a lot of sense. The reason it doesn't is that it's an exception. It says verifiable parental consent is required prior to any collection, use, or disclosure of personal information from a child, as set forth here, except in this paragraph. So this is an exception to 312.5. It includes an exception to 312.4, which means these options that I've highlighted in red, if you are only collecting data, again, assuming the FTC is right, for contextual advertising purposes, which fall under that definition, you no longer have to provide notice. You no longer have to obtain verifiable parental consent. That's what the FCC was claiming was your out in those comments to their 2013 rules. It says, hey, it will be eased. All of these burdens, they will be eased by the more limited definition of persistent identifiers and the more expansive definition of support for internal operations. So again, if we are evaluating this, if we are looking at this, you only start to have to talk about these other potential rules. You have to provide a reasonable means for a parent to review personal information. Again, that's upon their request. So the parent has to actually come to you and request it, and then you have to provide the personal information if they so request, which I will admit is a logistical problem We talked about this yesterday in the weaknesses of their case, but it is entirely unclear how a single persistent identifier is supposed to lead to you being able to have a parent contact you, know who they're talking about, and then provide all of this information that they would require. But the point of this video is to say, hey, that isn't the hardest thing. It isn't the hardest bridge until you have to cross it, because the trigger for this is that upon a request of a parent, you have to do these various things. So before that request, you don't have an issue. You're not allowed to condition participation in a game based on a collection of information, but that's probably not pertinent to a YouTube video, probably. I again, can't offer legal advice. There are certainly facts and circumstances that might jump out that would make it pertinent. And then you also have to establish and maintain reasonable procedures to protect the confidentiality, security, and integrity of personal information collected from children, which is a long legalese way of saying you have to go through the process of making sure that the third party whom is collecting this data for you is able to keep it secure. And I think, again, this is just an opinion. This is just a lawyer's opinion on these various things. But I think if you are in this situation where this is the only thing that you have to comply with on day one, saying, hey, we rely on YouTube to keep the information confidential. They are a giant corporation. They have all those privacy policies that Rick just talked about. We think it is fair to assume that we have enacted reasonable procedures by never taking possession of the information and instead leaving it in the hands of this giant corporation that hopefully has taken these steps that they have told us they have taken in their own privacy policies, that has to be sufficient to meet this condition. Which is all a long way of saying, when we talk at the start of this video about how can you be COPPA compliant pretty easily, the answer is you hit this button. Now, that might not be good for many people. That might not be good at the end of the day. I don't know that people have a lot of understanding of what hitting that button will do to their revenue if it's their livelihood on their YouTube channel. I'd be interested if people have delved into this button and what it does to their revenue after hitting it. But contextual advertisement is still a thing. Presumably YouTube is still serving up those context-based ads. And one assumes that this is their overall plan because when they describe what they are doing to meet the requirements of their FTC stipulated order, the primary thing is saying, we will stop serving personalized ads on content that is made for kids, whether designated by you or by our classifier. In accordance with COPPA, serving personalized ads to child audiences is not permissible. Now, again, we've talked about deception. We've talked about false YouTube language here. But if you're following along with this series, look at that sentence, right? COPPA doesn't say you can't serve personalized ads to children. It doesn't say you can't collect personal permanent identifiers of children. It says that if you do, you have to give notice to them about the information that you're collecting, and you have to go get parental consent. YouTube just isn't interested in that. And if you want to bring fire on the FTC, and I think it's worthwhile to do so in this case, I would also recommend talking to YouTube. Because you say, YouTube, you're in the best position to answer all these questions. We have no idea what data you're collecting. Please comply with COPPA. Because even the stipulated order doesn't say for you to do all this stuff. Doesn't say for you to turn off behavioral advertisements. All the stipulated order winds up saying is you will make it known to people that put stuff on your website that you are going to have these obligations, that you are not going to be able to avoid COPPA compliance solely by just posting on our website. It says you are enjoined from failing to develop a system for you to be able to identify your videos as for kids, and it'll include a notice that you might be obligated under COPPA and that you're otherwise obligated to YouTube to designate such content as directed at children. Now, as an aside here, I note that it doesn't actually require YouTube to obligate people to designate such content. It requires YouTube to notify people that they are obligated. That's a legal distinction there, and I don't think it matters much in terms of how you actually interact with YouTube. But it is funny to note that even lawyers at these kind of high-end levels that are dealing with $170 million settlements probably wrote that wrong. But the thrust of this settlement is you will get people to identify what is not and what is for kids. And otherwise, the next part is you will comply with COPPA. You are enjoined from violating COPPA. And you will provide notice to the extent you are able. You will get parental consent to the extent you are able. And you won't violate COPPA. It doesn't say anything about actually changing the services you can provide to people. It's just that YouTube is unwilling to comply with COPPA at its level. And so it's basically turning off all the buttons for everybody that deigns to say something they are creating is created for kids. They also are turning off a bunch of other stuff, which is one of the reasons why pressing the quote-unquote magic button might also be attractive as an option. To say, hey, I don't know whether this is directed at kids, but if I label it as directed for kids, a whole bunch of other stuff happens. It says the ability to comment will no longer be available on the watch page. Likes and dislikes and subscriptions on the content will not show up on public lists. Overall, viewers will have minimum engagements with made-for-kids content on YouTube.com. And you say, Rick, I've listened to this whole series. You talk a lot, but I have not heard one reason why YouTube would turn off comments and likes and dislikes and subscriptions related to COPPA. And the answer is it doesn't have anything to do with COPPA. The answer is at the same time YouTube was dealing with COPPA and the FTC, they were also dealing with stories like this. YouTube pledged to disable comments on videos with young kids. It hasn't. A pedophilia scandal spurred YouTube to pledge it wouldn't allow comments on videos depicting kids age 13 and younger. 6 months later, they're easy to find, etc., etc. YouTube has had scandal after scandal pretty much through its entire history, but it seems like it might be accelerating. And one of those scandals that was happening at the same time as all the stuff we are talking about with respect to COPPA is people making lewd, lascivious comments on teenage ballet recital videos and things of that nature. So at the same time that YouTube was dealing with this issue and complying with COPPA, or essentially saying, hey, we're not going to comply with COPPA, so everybody turn everything off if you direct anything towards kids, they were also dealing with this issue, and so they just decided to package them up all in one. But the primary comments that I'm receiving on these videos is I've looked at COPPA, potentially I've even talked to a lawyer, and nobody can advise me exactly what directed for children truly means. Because nobody has really litigated this through the court system. Everybody settles. The definition for directed to children seems vague as all get out. Because when we actually look at this definition, and we'll do it one more time for old time's sake, it says a website directed to children means a commercial website or online service that is targeted to children. That's the definition. Directed to children means targeted to children. Well, that's not terribly informative, and it's almost impossible to know what it means. So in order to give a little bit more context, the FTC added, in determining whether a website or online service is directed to children, the commission will consider this bucket of stuff. That doesn't actually change the definition. It still just is targeted to children. If you didn't target your content to children, technically, you should be fine. But the commission will say it can consider the subject matter, the visual content, animated characters, child-oriented activities and incentives, music, audio content, age of models, child celebrities, celebrities who appeal to children, language. Presumably, if you don't swear, you're more likely to be found directed to children. Hard to say. We don't really swear in virtual legality. Wonder if that'll come up. Or other characteristics. Now, that's an umbrella term if I've ever heard one. The FTC reserves the right to say, hey, that other characteristic, that means it's directed to children. And because people can't know exactly what they mean here, they say, Rick, I'm scared to death of the FTC. And I say, yeah, the FTC can cause significant problems. But we've already talked about one out, which is that this whole thing can only apply if you're commercial. So people ask about monetization. If you are not monetized, chances are you don't fall under operator, because there is still a requirement that it is operated for commercial purposes, because the regulatory authority of the legislature requires certain things. In this case, they have put it under the ambit of regulating commerce among the states. So it has to be a commercial purpose for their website. So if you're not monetized, you're probably okay. I will say this. If you are not monetized, there's still buckets that you could fall into that would create a commercial purpose. If you're only putting up videos to advertise that comic book you are making, then those are probably advertisements. Those are probably videos up there for a commercial purpose. You still might find yourself, if we allow the FTC's definitions, as we've said in this video, in that bucket of commercial purposes. But outside of that, if you're not selling something, if you are not soliciting business, and if you are not monetized, it's very difficult to see how even the FTC's attenuated interpretation of this language could reach you. Furthermore, if you hit the magic button, if you say, no, behavioral advertisement isn't okay, You can collect your persistent identifiers, but they only serve as contextual advertising. And otherwise, I lead people to say, hey, go talk to YouTube about these things because I've established reasonable procedures. We can provide reasonable means for a parent to review by saying YouTube has these policies over here, potentially providing a link in each of your videos. And you say, we are not for kids. Then it's very difficult to see how, even if the FTC turns around in its sweep, as described in their press conference, in the fish in a barrel scenario that a number of people have commented on, even in that case, if you have that box checked so that they can't use interest-based ads, it's very difficult to see how what you are receiving, if it is of benefit to you and you fall under operator and you're going to lose that case, then it's very difficult to see how you are in violation of the notice and consent requirements because they would appear very strongly to not apply to you. That's why YouTube is not saying they are going to get consent, is not saying they are going to give proper notice. They are promising to do certain things in that respect in the stipulated order, but for the most part, they are saying if you identify as directed for kids, we're going to check that box for you because we're allowed to continue operating as we have been as long as we don't serve you behavioral ads. That is what YouTube is attempting to accomplish, and if you are significantly worried about this, and you're worried about whether or not you are getting all the labeling right on your specific videos, one of the things you can do is check that box preemptively. Say, I'm not accepting behavioral ads on my channel, but I'm not identifying this as made for kids because I truly in my heart don't believe this was targeted at children. If it's animated, it's adult. If it's anything else that covers toy models or toys or Legos or something else, I believe in my heart I am targeting it at people that are over the age of 12. Then you can label it as not for kids. And if the FTC turns around on you, you say, okay, even if I am an operator of this website, nobody collected anything for my benefit. That persistent identifier wasn't used for my purposes. And even if it was only used in the context of contextual advertising. So I shouldn't be liable. I shouldn't have an issue with you, the FTC. Now, that doesn't mean that you won't. It doesn't mean that you can't get into a situation where the FTC can sue you. That's what we said at the start of this video. Anybody can sue you. So if the FTC decides to make an example of you, these arguments are very effective in court. These arguments are likely to be, I think, well thought of by various judges or arbitrators or wherever you might find yourself. But ultimately, it would cost a lot of money to get to that place, and that's why everybody settles. This has been Virtual Legality for today. If you enjoyed this video, please like, please subscribe, please share it around. If you caught it on YouTube, thank you so much for watching. And if you listened to it in its podcast form, thank you so much for listening. And I will catch you on the very next episode of Virtual Legality. Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.